Good morning, ladies and gentlemen. My name is Gillian Lumb, and I'm a director in the Employment Law practice of Klipdekker Hofmeyr. Thank you for joining us this morning. We hope that you will find today's webinar informative. While we may be coming out of the second wave of the COVID-19 pandemic, the significant impact on our economy of the pandemic and the lockdown persists, and the threat of a third wave looms. Given this harsh reality, we're going to focus today on the national minimum wage, what this means for job creation, retrenchments, and insolvency. More specifically, we'll be discussing, firstly, the increase in the national minimum wage and the annual earnings threshold, both of which are to come into effect as of 1 March of this year, and the impact of both of these increases on job security and creation. Following the Minister of Employment and Labour's announcement of the increase in the national minimum wage, there have been diametrically opposing responses to the increase. There are those who've expressed concern that the increase is still too low and that many are living below the poverty line. Others have raised a concern that many employers cannot afford to pay employees at the increased rates. In response, and in a statement released by the Minister of Employment and Labour, the Minister referred in the statement to the figures not being a thumbsuck, but following a considered process in which stakeholders were afforded the opportunity to be heard and give their input. Notwithstanding this, there are ongoing concerns that the increase may result in job losses. This then takes us into our second topic of retrenchments, and we'll be focusing on a decision of the Labour Appeal Court, which addressed the critical and often vexed issue of selection criteria. We'll also be looking at alternatives to retrenchment and in particular, the training layoff scheme. Finally, we'll discuss the interplay between retrenchments and insolvency. We will revisit the SAA in Business Rescue versus NUMSA 2020 judgment and the principles laid down by the Labour Appeal Court regarding timing in the issue of a Section 1893 letter. As more businesses find themselves in distress and file for business rescue, knowing when to initiate the Section 189 process and to furnish employees with the 189 letter is critical. Our speakers today, first off is Thabang, who will address the national minimum wage. I will then address retrenchments and the selection criteria. And finally, my fellow director, Phetheni, will address the interplay between retrenchments and insolvency. Our session is an hour, and we've left time at the end for questions and answers. So if you have any questions, please raise these as we go along in the Q&A, and we'll endeavour then to address these at the end of the session. I will now hand over to Thabang. Thanks, Thabang.
Thank you, Gillian. Good morning, everyone. As Gillian alluded to, I will be covering the issue of the changes to the new minimum wage. I will also look at the impact and the concerns. The exemptions will reflect briefly on the exemptions and look at the earning threshold, the changes in the earning threshold. Now, on the 8th of February 2021, the Minister of Employment and Labour published an amendment to the minimum wages. The national minimum wage is contained in Schedule 1 and Schedule 2 of the National Minimum Wage Act. These changes will only be effective from the 1st of March 2021. The changes are primarily as a result of recommendations that were made by the National Minimum Wage Commission. The Commission had recommended that the national minimum wage should be ideally applicable to all employees across the country, irrespective of sector. The National Minimum Wage Act establishes lower minimums for farm workers and domestic workers with a process of a gradual equalization of the national minimum wage over time. And that's what has been triggered in the latest, in these changes that will come into effect on the 1st of March 2021. The national minimum wage has been increased generally by 4.5%, with the increase for domestic workers and farm workers being rather high, and I will touch on those increments. In 2020, the minimum wage for farm workers was at 90% of the national minimum wage. The minimum wage of farm workers has been equalized with the national minimum wage for 2021. And this has resulted in an increase of 16%. So in essence, farm workers are now at the national minimum wage, which was not the case last year. The minimum wage of domestic workers in the previous year was at 75% of the national minimum wage, and it has now been increased to 88% of the national minimum wage. This has resulted in a 22.6% increments. I think it's important to note that as things stands, domestic workers are not at the national minimum wage. So let's just look at the figures briefly. The national minimum wage for 2020 was at 20.76 per hour. It's now going to be 21.69 per hour. For farm workers, it was standing at 18.68. It's now going to be 21.96. For domestic workers, it was at 15.57. It's now going to be 19.09. It's also important to mention that workers who have concluded learnership agreements are also entitled to certain allowances outlined in Schedule 2 of the Gazette. Now, let's just look at the concerns that have been raised. In terms of concern, I will focus on the concerns that are coming out of the agricultural sector in light of the 16% increments. The farmers' unions have warned of the negative effect on profitability and sustainability of the agricultural sector. And the warning are basically because of the double-digit increase in the national minimum wage. As I alluded to, is now it has increased by 16%. The argument raised by the farmers' unions is that traditionally it has been a labor-intensive sector, and in light of these increments, they may look into greater mechanization, which might lead to farm workers losing their jobs. And this is because before the increase in the national minimum wage, mechanization did not make financial sense because of the abundance of cheap labor, and that's how the argument goes. Now, the options of mechanization has become more attractive on the back of an increased wage bill for farmers. The increased wage bill for farmers may also result in increased production costs, and that's one of the risks that comes with the increments. Such costs will have to be passed on to consumers, which may result in food becoming unaffordable to the very same people that the government was trying to assist by setting the minimum wage. Another concern is that farmers who previously did not implement certain legally permissible deductions for benefits such as accommodation may start doing so. Now, there are exemptions that have been provided for by the Act, and Section 15 of the National Minimum Wage Act, read together with the regulations, provides an exemption process for employers. The exemption process is specifically created for employers who can show that they cannot afford to pay the national minimum wage to workers. An exemption will only be granted if the following criteria are satisfied by the applicant employer. 1, the employer cannot afford to pay the national minimum wage, and 2, representative trade unions of the workers have been meaningfully consulted, or in a situation where there is no trade union, that the affected workers have been meaningfully consulted. The decision-making, and it's important to note that the decision-making process in terms of this exemption is quite a rigorous one, and employees will need to ensure that they submit comprehensive financial and organizational information when applying for the exemptions. And there are instances where exemptions will not be granted. And these are, for example, where it's the wage is at 90% of the national minimum wage in respect of workers other than farm workers and domestic workers, or is at 90% of the national minimum wage in respect of farm workers, or 90% of the national minimum wage in respect of domestic workers. In those instances, exemptions will not be entertained. Another significant development that has happened is the increase in the earning threshold. You will recall that the earning threshold has been at 205,433.30. In fact, since July of 2014. The earning threshold has now been increased to 211,596.30. an increase of 6,163, which represents a 3% increment from the previous amount. And this will also be coming into effect from the 1st of March 2021. Now, Section 6 of the Basic Conditions of Employment Act, the BCA, makes provision for the Minister of Labour to publish a determination that will exclude employees earning above a certain amount per year from sections of Chapter 2 of the BCA. So the earning threshold also have an impact on the application of certain provisions of the Labour Relations Act, as well as the provisions of the Employment Equity Act. Now, for purposes of determining whether an employee earns in excess of an earning threshold, meaning earnings, one looks at the regular annual remuneration before deductions of income tax, pension fund contributions, medical aid contributions, similar payments, but it excludes similar contributions made by the employer in respect of the employee. This is subject to the proviso that the subsistence and transport allowances received or any achievement awards and payments for overtime worked do not fall within the scope of remuneration. Now, in terms of the Basic Conditions of Employment Act, employees earning in excess of the earning threshold are excluded from the provisions which regulate ordinary hours of work, overtime, compressed working weeks, averaging of hours of work, when we look at things such as meal intervals, daily and weekly rest periods, Sunday pay for night work, and pay for work on public holidays. So in essence, it now means those who are now earning at 211,596.30 will be excluded, as that was the case with the previous amount. Now, in terms of the Labour Relations Act, employees earning in excess of the earning threshold are not subject to the deeming provisions relating to the temporary employment service, the so-called labour broker. In addition, employees earning in excess of the earning threshold will fall outside the scope of the provisions relating to fixed-term employees who are deemed to be employed indefinitely after 3 months. In the absence of a justifiable reasons for fixing the term of contract. Now, briefly looking at the Employment Equity Act. In terms of the Employment Equity Act, an employee earning in excess of the earning threshold who has a dispute relating to an unfair discrimination is not permitted to refer the dispute to the Ccma for arbitration. The employee is obliged to refer the dispute to the Labour Court for adjudication unless the dispute relates to an alleged unfair discrimination on the grounds of sexual harassment or all the parties have agreed to arbitration. So it's important that it's quite a significant development, and it will affect quite a number of processes that are in terms of the Basic Conditions of Employment Act, the Labour Relations Act, as well as the Employment Equity Act. That will be the extent of my presentation today. Gillian, thank you.
Thank you very much, Thabang. As I said in my introduction, I'm going to address retrenchment, in particular 2 recent decisions handed down, one by the court and the other decision of the Ccma, both of which deal with retrenchments. I'm also going to discuss training layoff scheme, which is an alternative to retrenchment, which employers are being encouraged to consider by the acting UIF Commissioner. Last year, when we hosted a webinar in July, I also dealt with the issue of selection criteria. This continues to be an aspect of every retrenchment exercise, which actually trips out employers. In many judgments, retrenchment is found to be unfair because selection criteria were unfair, and/or because the application of the criteria is found to be unfair. As we all know, in terms of the Labour Relations Act, the selection criteria should in the first instance be agreed, and if the selection criteria cannot be agreed, then they should be fair and objective. In July of last year, when we discussed the case of SA Breweries versus Lowe, in which an employee was made redundant and had to apply with a new structure for a position, we looked at the decision of the Labour Appeal Court, which emphasised the fact that an employee's position redundant does not mean that the employee will necessarily be retrenched. After the employee's position was made redundant in that instance, he was afforded the opportunity to apply for a newly created position, which was a more senior position to his position. The employee was unsuccessful in his application and challenged the use of past performance in the appointment process. The Labour Appeal Court found that the application of the new position, or the applying for the new position, did not trigger the selection criteria for retrenchment. The performance rating and assessments of past performance were merely part of a competitive selection process, and that applying for the new position was not the selection criteria. The Labour Appeal concluded that there had been incorrect labeling of selection criteria. It was simply a selection process to a newly created position. This important distinction drawn by the Labour Court between criteria for placement within the structure and selection criteria for retrenchment was considered by the court again in the recent judgment of versus Van Staden and others. This is a decision handed down by the Labour Appeal Court on 1 December 2022. It involves an appeal against the decision of the Labour Court, in which the court found the retrenchment of 10 respondents substantively unfair and ordered Telkom to reinstate employees into the positions which they held prior to their retrenchments, or an equivalent position without loss of any benefits. I'd like to then just give you briefly an outline of the facts involving the case. Firstly, Telkom took a decision
Phetheni, we seem to have lost Gillian. Can you continue, please?
All right, not a problem. Thank you, Karishka. Good morning, everybody. My discussion is focused on retrenchments in the midst of business rescue proceedings. As Gillian mentioned earlier, I will be discussing the LAC judgment involving South African Airways, as well as NUMSA and other trade unions. The CIPC reported quite a spike in business rescue applications in the middle of 2020. Obviously, because of the nationwide lockdown and many businesses not being able to run their operations. Some of the examples of these companies that we've seen in the media include ComAir, Phumelela Gaming and Leisure, as well as the Edkin Group. There has been argument in relation to Edkin Group that was in the long time coming. And to back this up, there's been reference to the general change in consumer trend as well as preferences, and e-commerce becoming popular. I mean, a lot of people right now prefer to just click, buy, and have it delivered. That aside, it cannot be ignored that the financial impact of the COVID-19 pandemic and the resultant lockdown has had a dire impact on businesses and affecting the future of a lot of them, as well as bringing into question what happens when my employment is threatened as a result of business rescue proceedings taking place within my employer. Some of the questions that I've found landing on my inbox include: what are my employer's obligations if my employer is placed in provisional liquidation? Does Section 189 of the LRA apply when my retrenchment is contemplated? And can the company retrench? That's also quite a critical condition. That's quite a critical question. Just to put things into context, the South African Airways versus NUMSA decision dealt with the following facts. In December 2019, SAA applied for business rescue. A month before then, which was on the 11th of November 2019, the company or the company's management suggested that they relook their business operations to try and see if they could get the business to become viable again. As part of the process, they then issued Section 189.3 notices to employees who they anticipated would be affected by this process. About 944 employees were expected to be affected by this process. That is 944 out of about 4,700 employees. Soon thereafter, the company appointed business rescue practitioners and deferred the consultation processes that would flow from the Section 189.3 notices that were issued to January 2020. When the business rescue practitioners came on board, they re-looked at the operations, they tried to downscale. We've all probably heard about the time when SAA shut down certain routes, minimized certain travels along certain routes. Those were all part of measures. Those were all part of measures involved to try and save costs and make SAA viable again. As a consequence of that, what the business rescue practitioners opted for was to completely abort the impending Section 189 process at the time. NUMSA, on the other hand, perceived this relooking or realignment of business operations as commencement of a Section 189 process. They then approached the Labour Court on an urgent basis to declare those impending retrenchments, as they considered them, unlawful on the basis that the business rescue practitioners had not issued Section 189.3 notices. The court heard the application on the 14th of February and held that the retrenchments that they were referring to had been moot. What the business rescue practitioners were doing at the time was definitely not contemplation of retrenchments. After that matter was heard, on the 9th of March 2020, the business rescue practitioners then issued Section 189.3 notices to employees and invited them to consult. Considering the nature of SAA's operations, a period of about 60 days was allocated for the consultations. A few days later, on the 15th of March 2020, a national state of disaster was declared by the president. We then moved into a lockdown. On the 19th of March, the business rescue practitioners issued supplementary 189.3 notices, where they then revised from the 60-day period that was then shortened. They also outlined what they anticipated would be the impact of the lockdown on the aviation industry and specifically SAA's ability to earn revenue. Importantly, they also recorded that they now anticipated issuing letters of dismissals by the end of March 2020. NUMSA went back to the Labour Court on an urgent basis, arguing that the Section 189.3 notices issued on the 9th of March, as well as the supplementary notices that followed on the 19th of March, were unlawful, alternatively unfair, on the basis that the business rescue practitioners had not issued or published a business rescue plan. Linked to this was Section 136(1) of the Companies Act, which regulates or prescribes what the impact of such proceedings is on employment. Just to take you to that provision, it provides that despite any provision of an agreement to the contrary, during a company's business rescue proceedings, employees of the company immediately before the proceedings commence are to be employed on the same terms and conditions, except to the extent that, firstly, changes occur as a result of natural attrition. Secondly, the employees and the company agree on different terms and conditions of employment. Thirdly, any retrenchment of such employees contemplated in the company's business rescue plan is subject to Section 189A, Section 189 and Section 189A of the Labour Relations Act and any other applicable employment law. The Labour Court crystallized the question to be answered as follows. When can a business rescue practitioner start retrenchment proceedings under Section 189.3 of the under Section 189 of the LRA? The court held that the key or the answer to this question lies in the interpretation of Section 136 of the Companies Act. In this regard, the court held that there is complete protection of employees against dismissals where business rescue proceedings are underway. Furthermore, the right to fair labor practice, as enshrined in the Bill of Rights as contained in the Constitution, guarantees or at least seeks to protect security of employment. The court further held that Section 136 of the Companies Act establishes a precondition precedent for the commencement of any retrenchment proceedings. In summary, what the court then went on to find that is before business rescue practitioners can commence a Section 189 process, they ought to have at least prepared and formed and tabulated a business rescue plan. The court then found for NUMSA and held that the issuing of the Section 189.3 notices in March were irregular, unfair, and premature, accordingly directed that they be withdrawn. The decision was taken on appeal and decided in July 2020. On appeal, the court held that the Labour Court was actually correct in finding that business rescue practitioners cannot commence a process in terms of Section 189.3 in the absence of a business rescue plan. It does not necessarily have to be approved, but there must be a plan in place because Section 136 1B of the Companies Act makes it compulsory that before any Section 189.3 notices are issued, there must be such a plan presented to the employees. Furthermore, the court reiterated that the purpose of business rescue proceedings is to save an entire company or corporate entity. And naturally, this includes the preservation of jobs. Ultimately, the court went on to conclude that central to the task of a business rescue practitioner is to formulate or prepare a roadmap in terms of which the business rescue practitioner will endeavor to save a business. This cannot be severed from the preservation of jobs. In conclusion, the court reiterated that in that instance, the retrenchments would unfold as with any solvent company in terms of Section 189.3. However, in that instance, obviously, the business rescue practitioner would then take hold of the process. That concludes my discussion. I will hand over to you, Gillian.
Thank you, Phetheni. Apologies, everyone. This is one of the joys of working from home. I can take it back a little bit in my presentation. As I was saying, in July of last year, I discussed the case of SA Breweries versus Low, in which an employee's position was made redundant, and the employee was afforded the opportunity to apply for a newly created position within the new sector, which was more senior than this position. He was unsuccessful in his application and then challenged the use of pass during the course of the process. The Labour Appeal Court found that the application for the selection criteria for voting and assessment of past performance were merely part of a competitive selection process, and that applying for the new position was not the selection criteria for retrenchment. The Labour Appeal Court then summed up in saying that what was used by the parties was an incorrect labelling of selection criteria, where it was simply a selection process for a new, and a critical distinction between criteria for placement within a new structure and selection for retrenchment was considered and addressed again by the Labour Appeal Court in the recent judgment of Telkom SA versus Van Staden. This is a decision that was handed down by the Labour Appeal Court on the 1st of December of 2020. It involves an appeal against the decision of the Labour Court, in which the court found that the retrenchment of 10 employees who'd been retrenched was substantively unfair and ordered Telkom to reinstate the employees into the positions which they held prior to their retrenchments or equivalent positions without the loss of any of their benefits. I wanted to then take you briefly through some of the facts because I think they're important to understand the process that Telkom undertook. So it went through a fit for future business restructuring exercise, This was aimed at trying to flatten the structure and reduce the number of levels between the top management of Telkom and their consumers. And the reason for this restructuring was Telkom's decline in revenues, its market share and profitability. The employees who were potentially affected were 2,500 of their management and specialist level employees. In the new structure, there were certain positions that had been made redundant, others were merged, and certain new positions were created. There were 4 trade unions whose members were potentially affected by the restructuring process, and Telkom engaged with those 4 trade unions. There were also certain non-unionized employees who were affected, and Telkom consulted with them as a group of employees through group consultations. During the course of the consultation process, Telkom consulted extensively about the criteria that it was going to look at in placing employees within the new structure. And the criteria that it proposed were qualifications and experience, so best fit for the job, qualification and potential. Then if there was more than one employee who was qualified for appointment to the same position, last in, first out, and finally, employment equity retention. Employees were all permitted to apply for the positions through submission of written motivations. Given the number of employees involved who were potentially affected, Telkom didn't conduct individual interviews with all of those employees who might have been affected. They then had a placement panel which considered all of the applications and suitability for the roles. That panel made recommendations to a validation committee, which committee in turn made recommendations to an assurance panel, and the assurance panel then made the final decision on placement. And as I said, no interviews were conducted, but employees were placed based on criteria set in the job descriptions for the positions and specifications of each of the available posts. If employees weren't placed within the first phase of the placement process, they were given the right to lodge an objection. In response to an objection that any employee raised, they were given reasons for not being appointed. And if an employee after that process was still not satisfied for not being appointed, they then had an appeal process. There was an external HR consultant who chaired those appeal hearings. The employees were afforded the opportunity to appear before the appeal panel, and they could be represented in that process as well. The decision of the appeal panel was a final decision, and that was all in relation to phase 1 of the process. Phase 2 involved employees once again being able to apply for vacant positions, but there were less stringent criteria for being successful in phase 2. This process, as I said earlier, was extensively discussed with the trade unions and the non-unionized employees, and it was through the input of the trade unions that the objection and appeal process was introduced by Telkom. There was no agreement with the trade unions or the individual employees regarding the selection criteria for retrenchment. What was referred to in the Section 189 notice as the proposed selection criteria by Telkom was that employees who were not appointed after applying for positions through the placement process, that those employees would be retrenched. Ultimately, of the 2,500 managers whose positions were affected by the restructuring, about 100 employees were retrenched, and 10 of them referred the dispute to the Labour Court. The key issues which needed to be determined by the Labour Appeal Court, which ultimately heard the matter, was firstly, were the selection criteria that Telkom applied fair and objective, because in the first instance they hadn't been agreed, so they then need to establish that they were fair and objective. And secondly, whether those selection criteria had been fairly implemented by Telkom. The 10 employees who raised the dispute said that the criteria were not fair and objective, and that they had in fact been pre-selected for retrenchment. So even before the consultation process commenced, they'd been identified and selected for retrenchment by Telkom. When the Labour Court considered the matter, they found that the employees had been unfairly retrenched, that the retrenchments were substantively unfair. And they found that making employees apply for positions within a new structure was in and of itself unfair. And that even if it wasn't unfair, the method that was used by Telkom to place employees within the new structure was unfair. The Labour Court also took issue with the fact that employees weren't interviewed during the placement process, and that there was no appeal and objection process in the second phase of the appointment process or the placement process. So employees were then reinstated. The Labour Appeal Court found that whilst there was that it hadn't expressly been stated in the Section 189 letter that the selection criteria proposed and used by Telkom was non-placement in the new structure. So as I say, while they hadn't expressly said that in the letter, that was the interpretation, it was non-placement in the new structure was the selection criteria for retrenchment. The Labour Appeal Court was required to determine then whether non-placement within the new structure was a fair and objective selection criteria for retrenchment. The Labour Appeal Court, contrary to the finding of the Labour Court, found that requiring employees to apply for positions within a new structure is not inherently unfair if there's a legitimate reason to restructure and to place people within that new structure through an application process. The court then said that the role, having found that the role of an arbitrator or court in relation to a restructure where employees are required to apply for positions is to scrutinise the placement process and the decisions taken in terms of that placement process. However, whilst the court can scrutinise that process, it can't second guess the decisions of the employer. It cannot, for example, place its decision, the preferred decision of the court, in the place of the employer. It can't also determine the weight to be attached to one criteria over another, or replace, as I say, what it felt was the appropriate process that the employer should have followed in the view of the court. It must exercise some deference to the exercise of the employer's discretion in the placement. The court then concluded that it was empowered during the process of assessing or scrutinising the placement process to determine whether the objective standard of fairness had been met and whether that placement process was subjective, arbitrary, capricious or inconsistent, and if it was, that would then impact on the fairness. So as with the SA Breweries matter, the Labour Appeal Court in the Telkom decision drew the important distinction between 1, placement of an employee into a position within a new structure, and 2, selection for retrenchment of employees who have not been placed within the new structure. The court was clear that whilst the two are related, they are different from one another. In the first, that is the competitive placement process, the relative strengths and weaknesses of candidates are assessed, whereas in the selection for retrenchment, that involves, in the first instance, agreement on the selection criteria, or absent agreement on the selection criteria, the criteria must be fair and objective. In ultimately looking at the process that Telkom had undertaken in restructuring and placing people within the new structure, the Labour Appeal Court found that the placement process had been subject to extensive consultation with the trade unions and those non-unionised employees, that process had been consistently applied across all of the employees who'd applied for positions, that it wasn't unfair for Telkom not to have interviewed all of the employees, given that they could make extensive written motivations in support of their applications for placement, and that they were also given the opportunity to object and appeal against any unfavourable decision made by Telkom. There were also, firstly, the placement panel, and then there were the 2 further committees to verify and approve decisions about placement, and that employees who were not placed in the first phase were then given the right to apply within the second phase against less stringent requirements for placement in the second phase, and that in this particular instance, the 10 employees who referred their disputes had chosen not to exhaust the internal remedies available to them to challenge their placements, that through the appeal and objection process, they could have, at an early stage, raised concerns, and that potentially there could have been a rectification of scores if there was an issue, and also that if there were any other irregularities or errors, these could have been corrected at that early stage. Ultimately, the court found that in relation to the 10 employees, there had been no unfairness in relation to the placement process. There was no unreasonableness, no arbitrariness. It was not inconsistent in how Telkom applied that process, and that there was nothing unfair in the placement process and the selection used for that placement process. In conclusion, then, the Labour Appeal Court confirmed that the non-placement of an employee pursuant to a placement process is a valid selection criteria for retrenchment, provided, though, that the placement process itself is fair and objective, which the court had scrutinised in this instance. So I think this is a very important indication to employers when you're going to embark upon a Section 189 process and you're preparing your Section 189 letter, to ensure that you carefully consider what is the selection criteria and that you don't confuse the difference between a competitive selection process and the criteria that you use during the course of that process and the selection criteria for retrenchment, and that distinction, which is often blurred, is made clear from the outset in your Section 189 letter and then throughout the process. That then takes me to the second decision that I wanted to look at, which is a PE decision of the Ccma involving the liquidation of a business. It's the case of Abrahams versus Trish Swim School, and it's a decision that was of an arbitration award which was handed down on the 21st of October of last year. Very briefly, the facts were that the employee was appointed by the swim school as an administrative clerk. The swim school was closed at the start of the lockdown, so at the end of March, and only reopened in July of last year. And the employer claimed that her business was bankrupt. She was financially crippled. The business was bankrupt and she had to liquidate her business. And it was on this basis that she held a discussion in a coffee shop with the employee, advised her that she couldn't continue to employ her, and the employee was retrenched. The employer referred her dispute to the Ccma, and the commissioner found that the employer had provided no proof that the business was bankrupt or that it had been liquidated. In the circumstances, the employer was ordered to pay the employee severance pay and compensation equivalent to 5 months' salary for unfair retrenchment. During the course of the arbitration proceedings, and separate from the complaint about her retrenchment, the employee also raised a concern that she'd not been paid any COVID-19 TERS benefits while the business was closed, and that when she raised this concern with her employer, she was advised that she hadn't been registered with UIF. During the course of the arbitration proceedings, in response to this, the employer said that she didn't know about the COVID TERS benefits and that she wasn't aware that she could apply for those. The Commission, in response to that, ordered that the employer re-register the employee for UIF and apply for the COVID-19 TERS benefits for the employee. And why I selected this case is I think it's important to remind you as an employer, if you're going to retrench employees or look at retrenching employees because of your financial position, that it is absolutely critical, despite the fact that there's an acceptance that the economy is in a dire strait at the moment and many employers are suffering, is that you are able to establish and prove to the Ccma or the court that you are in financial distress. And secondly, that you look for alternatives to retrenchment. And given now that the Minister has extended the COVID-19 TERS benefits within certain sectors, that you consider whether applying for the TERS benefit for at least a period of time during the extended period will allow you to continue to operate your business and not have to retrench people. The requirement to look at alternatives takes us then into the final issue which I wanted to address, which is the training layoff scheme. This is a scheme which the acting UIF Commissioner, when releasing a media statement about the extension of the COVID-19 TERS scheme, encouraged employers to consider using. This scheme was introduced in 2009 in response to the global economic crisis, and as the UIF Commissioner has said, is something that employers should be encouraged to use again as we are in yet another economic crisis. The scheme is designed to give employers some relief where they are in financial distress. It affords them an opportunity to develop and implement turnaround strategies in an attempt to improve their financial position and avoid or limit retrenchments. So what it provides for is that an employer can be absolved from the obligation to pay employees their normal salaries for a period of time, during which the employer can then try and rebuild its business. During the period that the employer is absolved of that responsibility, the employees then are placed on training through the relevant CETA. So it has the positive spin-off as well, that employees then, there's an investment in their training and development of their skills. The scheme is a voluntary scheme, so it's something that the employer, and if the employees are unionized, that it would agree with the trade union, or if they're non-unionized, with the employees themselves. It's voluntary, so you would apply to the Ccma if you wanted to reach agreement on a training layoff scheme. You'd apply to the Ccma, which would then facilitate the negotiations and ultimately the compiling of the agreement relating to the scheme. And then they would ensure that the relevant requirements for the scheme are complied with. There is a cap on which employees can benefit from the scheme, so it depends upon the annual earnings of the employees involved. The employer, as I said earlier, is absolved from the obligation to pay employees their salaries during this period. It does, however, have to pay the employees a basic social package, which includes, for example, disability and death cover, pension or provident fund contributions, and unemployment insurance fund contributions. So there's that minimum package that the employer pays, but the balance of the salaries do not have to be paid. And there's a training allowance that's paid to the employees while they undergo training. That training allowance is set at 50% of the employee's basic salary, subject to an overall cap on the allowance paid to employees. So I think it's important to bear this in mind if you are facing possible retrenchments due to financial distress, that you consider the possibility of participating in the scheme, given that it allows some relief to employers from the obligation to pay their full payroll, and at the same time allows for an important investment in the reskilling of employees. So I think an important reminder of a scheme that's been in place, as I said earlier, since 2009 and has been successfully used by many employers, but one that I think needs to be reconsidered at this point, given the dire situation, the financial circumstances in which many employers find themselves. Thank you very much. If I can then just look at questions that have been raised. Thabang, if I can start with you. I know there was a question raised and a query about the entitlement to refer disputes to the CCMA relating to unfair discrimination. If you can clarify that issue, please.
Okay, thanks, Gillian. So on that issue, in terms of the Employment Equity Act, an employee may refer the dispute to the CCMA for arbitration if one of the three is present. One, the employee alleges an unfair discrimination on grounds of sexual harassment. Two, in any other case other than sexual harassment, if the employee earns less than the earning threshold, which has now been which will be increased from the 1st of March. So meaning if you earn above that, it will have to go to the labor court if we are not dealing with an issue of sexual harassment. Unless the parties, and that's proviso number 3, unless the parties to the dispute consent to the dispute being arbitrated at the CCMA. So I hope that has clarified that position, Gillian.
Thank you, Thabang. There was also a question raised, a query about the Telkom SA decision and a request that we give the citation for that decision. We will make that available afterwards, but it's just for clarification. It's Telkom SA SOC Limited versus Van Staden and others. It's a 2020 decision, and it's on judgments on line 49323. And as I said earlier, it's a decision of the Labour Appeal Court. Then in relation to retrenchments, there was also a query relating to whether employers have to consider the employment equity policy in placing employees during a restructure. As I said, that was something that Telkom took into account during the course of their placement process. It was the final criteria that they looked at, which was employment equity retention. It's not something that you're obliged as an employer to consider taking into account when placing employees in a new structure. And also, as we've looked at before, it's not something that typically is regarded as fair necessarily when looking at who you select for retrenchment. So separate from placement criteria is also the issue of selection criteria for retrenchment. And to date, our courts have generally said that you shouldn't be using employment equity retention as a criteria for selecting employees for retrenchment unless you've got a policy, a clear employment equity policy and a plan that speaks to and supports that. So it should not be used, it should be used with care if you're going to use that as the criteria for selecting employees for retrenchment. I'm just looking to see if there are any additional questions that have been raised. Thabang and Phetheni, were there any additional questions? I know that some of the questions have been addressed. If there are any additional questions that you'd like to just raise with everybody and address. Okay,
thank you, Gillian. There was another question on whether or not the increased earning threshold will also apply in cases where the deeming provision is invoked, and I've answered that question to say yes, indeed it will apply. It basically means insofar as we are dealing with cases where the deeming provision is invoked, where you read 205,433 and 30 cents, you will now have to substitute that with the new earning threshold with effect from the 1st of March 2021. So it will apply.
Thanks very much, Thabang. Thank you. I don't see any further questions that have been raised that have not been addressed. I'm hoping that that's a good sign that we've been clear in our presentations and everyone understands the critical issues that we've been addressing. I'm going to then give you back some time. I think we've got about 5 minutes that we're giving you back in your day. Thank you all for joining us. I hope that you found it informative and helpful in the way forward. I wish you well, stay safe. Thank you very much.